Do you really want those you leave behind not to have any certainty as to who's going to get what, even who's going to arrange the funeral? Who would I want to look after my finances if I lost mental capacity? But as Martin Lewis is very fond of saying, a power of attorney can be more important than a will. The simple answer is children cannot just step in and take over if you lose mental capacity. What happens if there's a dispute about your will after you die? The golden rule really is if someone dies leaving a will that you're unhappy about, get some separate advice. Hello, welcome to my podcast. And today we've got a slightly different format because following the various podcasts that we've done, appearances on radio and TV, and most particularly the Martin Lewis Money Show, where we spoke about making wills, powers of attorney, etc., I've had lots and lots of questions. So I've put them all together and I thought today I could start to answer some of them for you. I've got them over here. So one of the first and most popular questions that I'm asked is, do I really need a will if I don't have much money or property? You might not be surprised to know that the answer to that is not particularly straightforward. I would say that almost always you should have a will. And the reason for it is this. Do you really want those you leave behind not to have any certainty as to who's going to get what, even who's going to arrange the funeral? Because by making a will, you can appoint an executor, and that executor has the right to deal with everything from making your funeral to who's going to have your book collection to who's going to have the little bit of money that you might have in the bank. What is not much money or property? That depends on who you are. What you have is probably really important to you and to those you leave behind. It might be that you have a collection of things that are quite of sentimental value. It may be you have some things on the wall, some pictures, your family photographs, or it might be that you do the lottery. And as someone said to me, you might have a winning ticket and tomorrow you might be worth millions. So do you have to make a will? No, no one has to make a will. But if you want to have some certainty, to thank people, to let them know you've remembered them, because actually, if you think about it, the will is what you leave behind when you die. It's what people read and they understand what you wanted to happen. So I would always say making a will is a good way to sit back and think about what legacy you want to leave behind for those that you've loved and cared about during your lifetime. The next question is a little bit similar, and that is, my partner and I aren't married. What happens if one of us dies? Well, if you make a will, you can be certain as to what happens if one of you dies. But if you don't make a will, then the intestacy rules, sometimes known as the state's will, takes over. There are certain provisions for what happens to our assets if we haven't made a will. If, for example, you have children, they get all of your estate if you're not married. If you're married, then your spouse will get some of your estate, but not all of it unless you have no children. If you're not married, have no children, and parents are alive, then they will get your assets. Maybe that's not what you want, but the most important thing is if you have a partner, no matter how long you've been together, you could have been together for 50 years, you could have 25 children, you could all be living in a big house that's in your name. If you die, your partner doesn't get it. In fact, they get nothing. Yes, there are ways that they can get something. If you haven't made a will, they will challenge the estate. That's a legal contesting of the position. They'd have to go to lawyers, possibly have to go to court. It could take a long time. It could become ugly. There's not such a thing as a common law wife or common law husband. You have to be married or in a civil partnership to have the entitlement on death. So think of another situation. Think of a couple together, unmarried, living in a property owned by someone that dies. The one that's died is the parent to their young children. Maybe the children are aged 3 and 5. the partner would get nothing. The property would be held in trust for those children. It's a disastrous situation because young children can't make the decision to give up their entitlement for the parent. And so you have to go to court to get things resolved. So there is no need to have to get married in order to be sure of who gets what when you die. Although I will say the inheritance tax rules are much kinder to married people than to those that aren't. Again, it comes back to perhaps taking advice. Let's move on to the next question, which I thought was quite a fun question. It is about the difference between DIY wills versus solicitor-made wills. So can I write my own will at home and just get it witnessed? Yes, you can. A will is valid if it's on a piece of paper, signed in ink, witnessed by two people who witness each other's signature as well. So all three are in the room at the same time. That's a valid will. The interesting thing is a will can be valid and actually not say anything of any meaning. So one example that I genuinely saw was someone's homemade will that was brought to me by the daughter of the deceased many years ago. And he said, look at my mum's will. And it said, I leave everything to, and then there was a blank. But Mum had signed it. She got two neighbours in to witness it as well. But she had just forgotten to fill in the name. Worse than not having a will, because you have to put to probate that there is a will. You have to go through all that, but then you have to still work out what's going to happen. So yes, you can make your own will, and very often they're fine. But if you want to make sure that the legal meaning of the will is what you want it to be, and what the outcomes could be of what you're writing, I would always really recommend a solicitor-made will. They're the gold standard. So then we're asked, what's the difference between a power of attorney and a will? There's a huge difference. A will only has any effect when you die. So you could make 20 wills in your lifetime. Each one cancels out the one before. It's only the last one, that's valid when you die, and that's when people are allowed to read it and take notice of it. Whereas a power of attorney, it's actually only valid when you're alive, and it is the appointment of somebody to look after your financial affairs whilst you're alive. There is another power of attorney, and that's for health and welfare, which I'll go on to separately. But the one we're usually familiar with is the one that appoints somebody to look after your finances, usually if you lose mental capacity, but it doesn't have to be that. It could just be that you're going to be abroad for 5 years and you'd like somebody to be able to deal with your bills for you. Or it could be that you just really don't like dealing with your finances. Many people, as they get older, perhaps they find it a burden and they'd like that help. So a power of attorney is valid whilst you're alive, appoint someone to deal with your finances, doesn't give your finances away though, unlike a will. And then the power of attorney ends when you die. And if you've made a will, the will takes effect and the executors appointed in the will take over from the power of attorney. Hope everybody's with me because that was quite a deep one. Talking of powers of attorney, we're then asked, if I lose mental capacity, can my children just step in and make decisions for me? Well, it does depend on what decisions they are, but the formal and proper answer to that is no. If you lose mental capacity, which means you lose the ability to understand and make reasoned decisions, then you need a power of attorney if you've made one. And if you haven't made one, you need to apply to the Court of Protection for the court to appoint an attorney. But also there are varying degrees of losing mental capacity. Maybe it's difficult to understand your investments, but it's not difficult to understand that you don't feel well and be able to tell someone you don't feel well. Maybe you can't weigh up the risks of where you live and that you're likely to fall, but maybe you can say that you feel too hot or too cold. So there are various degrees of losing mental capacity. It's a really wide-reaching subject. But can my children step in? Would you want your children to step in? Would you prefer your partner to step in? Would you prefer one child after another? over another. The ideal way is to sit here today whilst you've got your mental capacity and think, who would I want to look after my finances if I lost mental capacity? Most of us think of losing mental capacity, of sadly getting dementia, because there's more and more of that now as we're all living older. And so we think we've got plenty of time to think about making a power of attorney. But as Martin Lewis is very fond of saying, a power of attorney can be more important than a will. Because what if you have a brain injury? What if you have a stroke? What if that's at the time when you're the provider for your family, when you're at work earning money, when you're dealing with investments? That's pretty disastrous if you lose mental capacity, because also who's going to look after paying for your care? So making a power of attorney is really important, and the person that you choose as your attorney is really important too. That might not be all of your children. It may not be your children at all. It might be someone professional. It might be a colleague. It may be a partner. It may be a combination of them. But no, the simple answer is children cannot just step in and take over if you lose mental capacity. So the next question is, how do you choose the right person to act as an attorney? There are two types of power of attorney. One is in respect of finances and property, and one is a separate document, and it's a power of attorney in respect of your health and welfare. Now, if you're like me, I know which of my children I would like to look after my money, and which of them I'd prefer to be speaking to the doctors about what care I need. So you might be in that position. You might think, that child is loving, cares about me, but is actually pretty not good with money. Whereas another child may not be good around hospitals and doctors and care. So the very best way to deal with it is actually to think about what the attorney's role is going to be and how you want them to be, what you would want for yourself if you had lost capacity, and that's how you choose your attorney. It's a really difficult conversation to have, firstly with yourself and then with the people that you're choosing, or perhaps the people that you're not choosing. Transparency is really best, but this is your life and your choice, and I would say it's the most difficult thing is to decide not to choose someone as a power of attorney. And what you really shouldn't do is choose somebody because they'll be offended if you don't, because it's a hugely powerful position to be in. So yeah, it's a difficult one, and it's a really good question by the person who put it to us. And the last question is a really big question, and that is, what happens if there's a dispute about your will after you die? It depends what type of dispute. It depends whether somebody's saying this will was a forgery, or this person making the will didn't have all their capacity, or they were being coerced, or if, going back to the beginning of this session, they're challenging the will because they think they need provision. What if you're sharing a home with somebody? You live there, you don't pay rent because you're in a relationship, and then that person dies and you find they've left the house to a charity or to someone else. You're going to be a bit upset because you had thought you had a home for life. That may well be grounds to dispute the will, and that's a particular type of court action. Disputes after the will, after death and on a will, are time sensitive, so it's really important to act quickly to get advice. Because apart from the fact that the executors of that will could quickly deal with the estate and the funds could disappear, there are also limitation periods where after which time the court is not going to look at your claim because they're going to say you're out of time. The golden rule really is, if someone dies leaving a will that you're unhappy about, get some separate advice. Go to see a solicitor and explain why you don't think this will is right and why you think that it should be challenged, and you'll be advised as to whether those are decent grounds to challenge the will. And if you take that advice, it's really important to be totally frank about what you knew about the situation and what your feelings are. Any solicitor meeting with you will act in your best interests. And so you must say, I was being funded and supported by that person, or I was promised that I would get this, or do you know what? The person definitely would not have done this. They would not have made this will of their own free mind. And then those situations can be explored. So there's no one answer to that question except to say, if it doesn't seem right, then go and get some advice and see if, in fact, there was something wrong with the way that will was made and there's something you can do about it. We've come to the end of this podcast, and I hope that this got your interest in terms of some of the questions. As I say, we had lots and lots of them and tried to select those that seemed the most often asked questions that gave me an opportunity to explain this area of law to you. Thank you. If you have a question, please email me at yourquestions@melindagiles.com. I look forward to hearing from you, and I will do my best to answer as many as I can.